Hi folks, and welcome back to Contract Law. This is video 3 in the video series on the vitiating factors of misrepresentation and misleading or deceptive conduct. And in the first video, we had an overview and we started to look at misrepresentation at common law. We stepped through the elements. And then in the second video, we finished off misrepresentation at common law by looking at the 3 categories of misrepresentation and also a little bit more of an exploration of the remedies that are available, in particular rescission and the bars to rescission. In this video, we can all breathe a collective sigh of relief because we finally get to look at misleading or deceptive conduct under the Competition and Consumer Act, particularly Schedule 2 of that Act, which is the Australian Consumer Law. Lovely little provision, and I'm sure by the end of this video and the next video, you will agree. So looking at the competition and consumer legislation, there are a few things that we need to bear in mind. As you can see up the top there, that's the legislation that we're dealing with, the CCA, and the ACL is Schedule 2 of the CCA, as I said. We must flag for attention that there has been mirroring legislation in all states and territories, and I'll go into that and the reasons for that in just a moment. The big limitation that you have to remember with this legislation, as lovely as it is that it only applies where the representor is acting in trade or commerce. In trade or commerce, that means in some kind of commercial capacity. We'll talk about that element more in just a moment, but what it does mean is that it knocks out application of the legislation wherever you have 2 parties acting in a purely private capacity. Okay, so there is your big, I guess, unfortunate flag for this legislation. So you can see there, I've given you a screenshot of Schedule 2 down there, Part 2.1, misleading or deceptive conduct, and I've got a big red arrow, misleading or deceptive conduct, and I've set out the provision there for you. A person must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. So they are the elements. They seem nice and easy peasy, and compared to common law, I guess they kind of are. The first thing is to note the use of the word person, and that's fairly deliberate. You've got to remember the Commonwealth legislation came first here, and the use of the person was deliberate because it applies to both natural persons, that is living bodies like yourself and myself, and legal persons, that is, as you call them, artificial persons, companies, corporate persons, which the law treats pretty much as having the same rights and responsibilities as a natural person. Now, if you have a little bit of a think back to Introduction to Law,
ain't nobody got time for that.
And you will remember, hopefully, that the Commonwealth's legislative powers are set out in Section 51 of our Constitution. The Commonwealth only has the designated points of legislative power that are set out in that provision, and they don't have a general power to legislate over people. Okay, they've got to stick within those heads of legislative power in Section 51. In contrast, the states have a very broad-based legislative power. They can pretty much legislate about anything that happens within their jurisdiction. So because the Commonwealth's power is constrained in this way, the legislation was drafted to rely principally on Section 51 sub 20, it's the little Roman 20, 2 X's, and that head of legislative power relates to foreign corporations, and here's the big ticket one, trading or financial corporations formed within the limits of the Commonwealth. So as this legislation was first drafted, it was mainly aimed squarely at companies, okay? Regulation of naughty companies misleading consumers. That was the original intent. The legislation, Commonwealth legislation, can actually extend its reach to bite into the conduct by natural persons if the conduct transverses one of the Commonwealth's other legislative heads of power. And here there are two heads of power that you need to be aware of: the trade and commerce with other countries and among the states' power. So if a natural person is doing something in relation to trade in an interstate scenario, then that conduct will likely be caught by the CCA. Similarly, if conduct by natural persons involves things that are controlled by the Commonwealth and enumerated in the head of power under section 51 sub 5, postal, telegraphic, telephonic and like services, if the conduct involves one of those, then section 18 can apply to that natural person's conduct. So you can see there was a big lacunae, nice word, there was a big gap in the way that this legislation could apply. And so what the states did in 2010, when the old Trade Practices Act morphed into the Competition and Consumer Act, is that the states all got together, and there were many, many conferences and many, many meetings about the limits of Commonwealth legislative power and the states not wanting to give away too much of their power. And
Perfect.
they finally agreed that the states would actually enact mirroring legislation in every state and territory in Australia. And because the states and territories, as I said, have this broad-based legislative power, they can legislate in relation to pretty much any conduct of natural persons or corporate persons that occurs within their jurisdictions, has some connection with their jurisdiction. So the states mirroring legislation, now that it's all in place since 2010, means that the conduct of any corporate person or natural person will likely be caught by this legislation, either in the Commonwealth form or in the states and territory mirroring legislation form. So that is the issue to do with persons. Okay. The next element or requirement is that the person's conduct be in trade or commerce, and this is the big limitation that I mentioned previously. So, for example, the legislation won't bite on conduct such as, a little person selling their own private residence in a private capacity. So it might catch somebody that flipped houses for a living, for a business, obviously, because that's in trade or commerce.
You're buying a house, you're making it look nicer, and you're selling it for more. Like, that is what you have to remember.
But someone just privately selling their home, no. However, that big red flag aside, what will constitute trade or commerce has been interpreted by the courts in a fairly liberal fashion, because as you can imagine, this was originally drafted and still is applied as consumer protection legislation. So the court wants to throw the net as widely as possible to catch as much naughty commercial conduct as possible. So in Concrete Constructions and Nelson, it said essentially anything with a trading or a commercial character or flavour to it will qualify. In that case, some instructions from a senior supervisor to a worker that just carried out the instructions, and the instructions were wrong and resulted in some injury, those kinds of instructions or representations by that supervisor were not in trade or commerce. They were simply part of an employee telling another employee what to do, okay? They didn't involve that typical trade element, sales, commerce element to it that you would get in trade or commerce, okay? So that kind of thing will fall outside. Trade or commerce, as I said, anything that involves sales, selling, has a commercial flavour to it, flipping houses, that kind of thing will all qualify. There was a bit of unclarity around charities, and I think the text suggests that charities might fall outside the legislation. However, if you look in the ACCC guidance documents for charities, It actually says that if they're fundraising in an organised, continuous and repetitive way, they better watch out because they are probably fair game for the Australian consumer law provisions. Like I said, you can see why. The intent is that the net be cast very broadly to protect as many consumers as possible. So that's in trade or commerce. The next element is engage in conduct. And here, I guess, it becomes clearer just how much easier it is to deal with the legislative form of misleading or deceptive conduct than it is misrepresentation at common law. The equivalent element at common law would be a false statement of fact. So you're limited in many respects to an actual past or existing fact. And then if you want to argue opinion, intention, silence, there's all these exceptions and exclusions. In the legislation, conduct is defined in Section 2, Sub 2 of the ACL. And that definition says that conduct is doing or refusing to do any act. Doing or refusing to do any act. So immediately you can see you are not limited to statements and you are not limited to past or existing fact. So it frees you, to some extent, from the shackles of or confines of the common law. Immediately you can see Section 2, Sub 2, Sub C goes to the heart of actions that turn on silence. So refusing to do an act includes a reference to refraining otherwise than inadvertently from doing an act, okay? So if you deliberately refrain from doing something, that is speaking up, then that conduct will be squarely within the realms of Section 2, Sub 2, and that conduct may well fall within Section 18. So that's the first thing to note. Now, because sums can fit within the definition within 2.2, it's going to be treated like pretty much any other kind of conduct. So you'll just have the standard test for misleading or deceptive conduct being whether or not it leads into error. We'll talk about that in just a moment. The question of whether it is misleading or deceptive to not speak up will be whether there was a reasonable expectation in the circumstances that that person should have actually made the statement, disclosed the matter, whatever it is that's being argued by the plaintiff, whether there was a reasonable expectation. So that kind of issue is going to be determined objectively. It's going to depend on whether the silence was in people of equal standing or whether it was one of them had more information, knowledge, expertise, so on. So whether it was between, for example, a retailer and poor old Mr. Joe Public that had less information, or whether it was between two commercially astute and legally advised parties, as it was in Miller and BMW. And in that case, we had a timber company that engaged Miller, who was an insurance broker, to act on their behalf in their negotiations for a cost of production policy, the insurance policy that the timber company wanted to procure, and it sought finance from BMW Finance to fund the insurance premiums. Bit of a litany of errors on BMW's part. BMW's evidence indicated that it really only wanted to fund the insurance policy if it was cancelable. Originally, Miller's application was for a non-cancelable policy. The company and Miller put the application into BMW, and because of an administrative error, BMW just approved it without looking too hard at the fact that this was a non-cancelable policy they were to be funding. So the timber company paid its first instalment. They thought everything was going along fine. Then BMW discovered their error and say to the insurance broker that they need to tidy up matters. They requested further information from the timber company, and a certificate of insurance was provided and details of certain properties that were to be insured. BMW then backed out of that loan, and the parties re-entered negotiations for a loan of a shorter duration. And in the course of that application, which was pretty much on the same terms except for shorter duration, Miller sent BMW the fateful document bundle that included a stack of information, including the insurance policy that funding was sought for. It was, as you guessed it, it was non-cancelable. And as you guessed it, BMW approved this loan as well. And then discovered that they had approved for the second time a loan that they didn't really want to be involved in, and alleged misleading or deceptive conduct. As I said, they were unsuccessful there. The court does very helpfully go through the issue of silence and when silence can be actionable, and they formulate this test of a reasonable expectation. You can see the court's disdain for BMW's arguments, particularly, as I said, both parties were commercially astute, BMW being, one of the bigger financial lenders in the market. So that went down in flames for them. But as I said, the test that came out of that case was quite helpful. What about opinion? We saw that could be problematic sometimes at common law. Again, opinion may well be actionable as conduct within Section 2, Sub 2. And Chief Justice French in Campbell and Back Office Investments said that opinions are judgment or belief of something as probable, though not certain or established. And he noted that there's a clear overlap between opinion and fact. So it would tend to fall within Section 2, Sub 2. Here, the ACL, the interpretation of the provision has been influenced by the common law, and similar kinds of themes are going to guide a court when they're trying to work out whether an opinion is misleading conduct within the ACL. It possibly could be actionable if the opinion, obviously, like good old Edgington and Fitzmaurice at the common law, if the opinion was not held when it was given, so you're telling a porcupine, or where it lacked any reasonable foundation, so not reasonably held. These kinds of themes, as we saw in the common law, do tend to reach over into interpretation into the ACL. But again, you're not worried about having an element that ropes you into having a statement of fact, because you've got that friendly definition in Section 2, Sub 2. Opinion certainly can qualify as conduct. The test, as we'll see in a minute, is still, did it lead into error? What about intention, promises, and future matters and representations in those respects? Just because a prediction or a statement of intent doesn't come true doesn't necessarily mean that it's going to be actionable. So you can't get too slap happy with Section 18 of the ACL. It's not the cure-all for everything. So you just need to be a little bit cautious. However, again, a bit like the common law, statements of intention can be actionable if there's no actual intention held when it was expressed, or if there's no basis for making the representation. James and ANZ Bank is your authority there. Now, however, I want you to note Section 4. Section 4 of the ACL has been played around with by the legislature. There's been numerous amendments to Section 4, but it specifically addresses the issue of representations about future matters. And this is an evidentiary provision, and it certainly does help plaintiffs when they are trying to make a case of a misleading representation about things that are going to happen in the future. Have a look at this. It says, if a person makes a representation with respect to any future matter, and the person doesn't have reasonable grounds for making that representation, the representation is taken for the purposes of the schedule to be misleading. It's taken to be misleading. That is, it is presumed to be misleading. So it all turns on having reasonable grounds. Now look at this further, sub 2. For the purposes of sub 1, regarding a proceeding concerning a representation made on a future matter by a party or any other person, that person is taken not to have had reasonable grounds for making the representation unless evidence is adduced to the contrary. Wow, what a leg up, what an advantage this provision is for a plaintiff. What it means is, if the defendant can't adduce evidence for the court of this basis of reasonable grounds for making that representation about the future matter, then their conduct will immediately contravene Section 18, okay? If they have no evidence for making that statement, their statement will contravene Section 18. If they can adduce evidence, what the court will do is they will assess the evidence as to whether or not there were reasonable grounds, and then they will have to, the plaintiff will have to prove their case, that is, prove that the representation about the future matter was in fact misleading. Okay, so a nice little evidentiary provision for you to be aware of when we're talking about future matters. And that's the end of the third element of engage in conduct. What I might do is leave it here because we've hit the 20-minute mark, and we will come back for our fourth and final installment in this video series on misleading or deceptive conduct. So till then, bye for now, guys.